Welcome to our Law for Community Workers series, wrapping up what's new in the law in 2024. My name is Natalie, and in this episode, I'm talking to Kyla, a lawyer at Legal Aid New South Wales from our NDIS team, about some important changes to the National Disability Insurance Scheme. Before we start, we would like to acknowledge the traditional custodians of the land we are recording on today and pay our respects to elders past and present. Just a reminder that this podcast is general information only and cannot be relied on as legal advice. The information is correct at the time of publishing but may change. If you need help about a particular situation, contact our team at Law Access New South Wales via web chat, through the Legal Aid New South Wales website, or call 1300 888 529. Thanks, and let's get started. Hi, Kyla. There have been some substantial changes to the NDIS in 2024. Can you tell us a bit about those changes?
Thanks, Natalie. The first of the big changes that came into effect on the 3rd of October relates to access to the scheme. To be clear, how a person gets access, whether by meeting the disability or the early intervention criteria, hasn't changed. However, under the new legislation, the pathways are going to be more distinct, and the impairments for which a person gets access to the NDIS is going to matter. So people who newly gain access to the scheme from January 2025 will receive a notice of impairment telling them through which pathway they've got access and for what impairments. We don't know what these notices are going to look like yet, but we think that they'll categorize impairments as intellectual, cognitive, neurological, sensory, physical, and psychological. Anyone who's an existing participant can expect to receive a notice of impairment within the 5 years of transition that's provided for in the new legislation. So, if participants don't agree with their notice of impairment, they can ask for it to be varied. And if they're still unhappy, they can follow the usual review and appeal process. So, the second big change is in relation to revocation. There's always been a power of revocation under the scheme, but new powers are going to enable the NDIA to ask a participant to provide information or ask them to undergo an assessment if they're considering revoking their status as a participant. There are also revocation powers under a new section. It hasn't had its rules developed yet, but we think it will specifically look at early intervention participants and whether their supports are delivering the anticipated benefits.
So, Kyla, when you say revocation, do you mean people will have their supports under the NDIS taken away?
Yeah, that's right, Natalie. What will happen is that they will have their status as a participant revoked, so they won't have access to the NDIS at all anymore.
Kyla, can you just also explain what you mean by NDIA?
So that's the National Disability Insurance Agency, and they administer the NDIS or National Disability Insurance Scheme.
Thank you. All right, so we're up to the third change.
The third big change relates to supports. So, under the new law, for a support to be considered reasonable and necessary, it will have to be specifically related to a participant's impairment. Also, there are now lists of what are and aren't NDIS supports. A participant's supports must come from the list of NDIS supports. These supports more or less reflect what's already been happening in practice.
Thanks, Kyla. So, can you please give us some examples of what was already happening in practice?
So, examples are that swimming pools were never paid for under the National Disability Insurance Scheme, and wheelchairs always were, provided that they were related to somebody's disability or impairment. The new law includes a replacement rule, so a participant can request the recognition of a substitute support under the replacement rule on the basis that it does the same job and is cheaper than the one on the list. The fourth change is new framework plans. Participants are going to transition from old framework or current style plans over the 5 year transition period. A new framework plan will be based on a needs assessment, which will establish a participant's reasonable and necessary support needs and then use a formula to calculate the person's budget for flexible supports and for stated supports. At this time, the details and the rules about the formula are still yet to be developed. So we don't really know what that's going to look like yet. A new framework plan will be longer. It'll be up to 5 years long, broken down into 12-month funding periods. The final change is that there are now going to be more limits on management of funding and more consequences for failure to properly use and acquit funding. Participants will still be able to state their goals in relation to fund management, but under the new law, there are now going to be extra grounds to refuse self management and plan management requests on the basis of risk or mismanagement of a plan. While there's always been an obligation to properly acquit or use funding, there are now more consequences for not using funds in accordance with the plan.
Thanks, Kyla, for explaining the changes. So, what should community workers or support workers look out for in relation to these changes?
Thanks, Natalie. That's a really good question. In terms of access, if someone receives a notice of impairment that doesn't list all the impairments for which they require support, you can support them to get legal advice about adding in impairments. In terms of notices, the most important thing in relation to the new changes is that participants don't ignore notices or their time limits. So you can talk to clients about the way they're receiving correspondence from the agency and encourage them to reach out for help if they're having trouble reading or understanding their correspondence. So participants can expect to receive a notice that the agency wants them to undergo a needs assessment. They might receive notice that the agency wants information for the purposes of preparing a new framework plan. They might also receive a notice requesting information for the purposes of the agency considering revocation. Participants will have strict time limits to respond to these notices. If they don't respond within the time frame set out in the notice, their access to the NDIS may be suspended or revoked. These decisions can be reviewed or appealed on the basis that non-compliance was reasonable. However, their plans will remain suspended or revoked until the review or appeal is determined, which means they won't be able to fund their usual supports. It will therefore be important to action any notices from the agency, including by asking the agency for an extension of the time limit. In terms of acquittal of funds, it's important to note that failure to use funding in accordance with a person's plan could lead to a debt being raised. There's a transition period for the new support list, so a debt won't be raised in the first 12 months for accidental mistakes, unless it is a willful or deliberate breach of funding. People can't ask for a review of a debt that's been raised against them, but what they can do is ask for a waiver or write off of the debt. And if that's refused, the ordinary avenues of review and appeal can be followed. So it's really important to note that under the legislative changes that came into effect on the 3rd of October 2024, there aren't changes generally to review rights. So an internal review of an NDIA decision needs to be requested within 3 months of receiving the decision, and an appeal of an internal review decision should be made by application to the Administrative Review Tribunal within 28 days of receiving the internal review decision. Legal Aid is available to provide free, independent advice about NDIS problems. Legal Aid branches all over New South Wales can tell participants and prospective participants about their rights and what they can get from the NDIS.
Thanks, Kyla, for explaining all that to us today. I think not ignoring notices and being aware of time limits is such a universal thing lawyers say in so many different areas of law. So that's really an important message for community workers to be on top of. So thank you very much today. I think you've given everyone a really good overview of the changes and what to look out for.
Thanks, Natalie.
That's all for this episode. Thank you again to Kyla for chatting with us. You can check out our other episodes in this series, wrapping what's new in family law and criminal law. We'll put the links to those and more in the show notes. Bye for now.